Our next and last topic is infringement. What is it and what is required to improve infringement? This is the lawsuit component. I introduced this generally under the exclusive rights section, specifically as it relates to copying or the reproduction right. Copyright infringement is the unauthorized use of a copyrighted work. More specifically, as defined in the statute, Section 501A of the Copyright Act, it provides that an infringer is anyone who violates any of the exclusive rights of the copyright owner. So the first question is, what court has the power to hear copyright infringement cases? And this is kind of a revisit from week 1 when we were talking about the court system. Hopefully you remember the answer. The concept of jurisdiction, again, this is kind of review. This is the court's authority to hear a case. So what court has the power or the jurisdiction to hear copyright infringement cases? Federal courts, per the 1976 Copyright Act. At that point, copyright law became exclusively a federal law. Therefore, cases involving copyright infringement are heard in federal courts. There are actually 2 questions involving copyright that can be heard. There's only 2 questions. The claim has to be one for copyright infringement, i.e. you're using my song without my permission, you're using my photograph without my permission, you're distributing my work without my permission, or you've created a derivative without my permission. Any one of those exclusive rights. So the claim has to be one for copyright infringement. So any one of those exclusive rights, reproduction, distribution, derivative, display, performance, you're singing my song in a club without my permission. That's actually an infringement. We've talked about public performance. The other type of case involves claims that require the court to interpret the Copyright Act. What something means in the act itself, in the language, in the statute, or a particular provision of the law. So those are the 2 questions that the federal courts hear, that related to copyright, that they primarily hear. So what the courts do not hear are cases involving breaches of contract. There was a contract between two parties relative to some sort of ownership. That's a breach of contract case is not exclusively heard in federal court. It may be heard in federal court, but it also may be heard in state court. The court does not hear cases regarding ownership itself, like who owns the copyright, who's the owner. This can be heard in any court, or any state court or any federal court as well. Registration. As a prerequisite, we talked about this under formalities. Registration of the copyrighted work is now a prerequisite. This was a recent Supreme Court case. The work must be registered with the U.S. Copyright Office before someone can bring a claim in federal court claiming copyright infringement. But as we know, when a work is deemed protected by copyright, that's at the point of fixing that work in a tangible medium. So why do we have to register? Well, now it's because the Supreme Court says so. But reality is the registration puts someone on notice that you're the owner, that a owner of a work is the owner. Also, if one wishes to take advantage of the remedies, what you get when you win, an infringement case that are outlined in the copyright statute, to get those, you got to be registered. If you didn't register, though, the question is all lost, meaning you lost your copyright because you didn't register? No, you lose your opportunity to sue. However, you can register at any point. Let's say you didn't register, but now you want to sue somebody for using your work or infringing upon your work, didn't have your permission. You have to go and register first. Go and register and then bring the lawsuit. So it's not all lost. You don't have to register upon creation, even though that's a good idea. You can register and then bring the lawsuit because it's a prerequisite. Otherwise, the case is subject to be tossed out by the court. However, there was a recent case earlier this year that an individual did that. They filed first and then ran down to register the work, and the lower court dismissed the case, indicating that the registration must precede the filing of the lawsuit. But the Court on Appeal reinstated the lawsuit, saying the party could just amend their complaint to fix the date of registration rather than suffer the dismissal of the case. So you can change your paperwork and say that, if you do it flip-flop or backwards. So not all is lost. But it's certainly a good practice to register as soon as possible after fixing the work in a tangible medium. Let's talk about this concept of standing. It's a legal concept. Who can bring an infringement lawsuit? Only the legal owner or beneficial owner of the work at the time of the infringement. This is the concept of standing. Think of it as you must have a legal stake in the case. So let me define a couple terms here. Legal owner is someone who owns the work, right? The one who has all of the exclusive rights, the legal owner. Or beneficial owner has standing to bring a suit. Who might be a beneficial owner? In the simplest of terms, you could say it as somebody who has some sort of benefit that is driven from this copyrighted work. So let's say, for example, one who has sold her legal rights, but then retained an interest in the copyright. So, for example, an author sold her copyright to a publisher in exchange for receiving 10% of the revenue publisher gets from that work. The author benefits, or i.e. is a beneficial owner. So if something, some infringement occurred, that author would have the right, as well as the publisher, to go and sue for infringement. Another example is the owner of an exclusive right. Let's say a book gives another person one of their exclusive rights. Let's say to make a derivative. So we have our book who gives a exclusive right, meaning they're the only ones who can use it and have it, exclusive right to a movie company to make a movie. That movie company now is a beneficial owner. They stand to benefit from one of the exclusive rights. So if some other outfit was going to make a movie on the book or infringe on the book itself, that owner of the exclusive right, that movie company, is a beneficial owner and can sue. They have standing. If, let's take this example, if author sold his work to Bob today and Sally uses the work without permission 2 weeks later, who can sue? Bob, right? Bob is the one who has the ability to sue because Bob has the copyright. He is the owner of the copyright at the time of the infringement. The owner can. The author can't. They just gave that away to Bob. If the author works for Apple, making software, and somebody infringes on software created by that author during the course of his employment at Apple, it's Apple that has the standing to sue, not the author. Why? The author is a work made for hire. What about a joint authorship situation? We got a 50-50 joint relationship. Two filmmakers created a documentary. Who has standing to sue? I hope you're saying both of them. Yes, they both do. They can either one can sue or they both can sue together. They both have the standing to sue. What do we need? What does a plaintiff need to sue and to win? What do they have to establish to win a copyright infringement case? There are two elements they have to show. One, ownership of a valid copyright, and two, copying of the constituent elements of the work that are original. Remember, not those Santa Fe ones or the idea behind it. They have to copy the elements of the work that are original. So let's break this down. Ownership of a valid copyright. Well, you need a valid work, right? Something that is copyrightable. What might not be valid or not copyrightable, or copyrighted? Well, it lacks originality. It's kind of a recap. If it lacks, the subject matter lacks originality. It wasn't fixed in a tangible medium. A work that may be owned by the government. The work's owned by the government. Government can't come in and sue. It's in the public domain. Non-creative elements or factual aspects that are copied. How about the copyright expired? There's duration issues. Might not be copied. Was there timely registration? Remember, we have those little hiccups with the duration issue and the duration where, depending on where it falls in, if you didn't register or have a notice on your work, formality problem. Question might be, is the plaintiff the actual owner? They have to be the owner. The plaintiff has to be the actual owner. And now there has to be proper timely registration. Those two things are going to be key right out of the gate. Are you the actual owner, plaintiff? And two, did you register? And then all of those other things will kind of flush themselves out, as you'll see when we go through an example. So copying the copyrighted elements. And for this particular factor in what the plaintiff has to prove, this one has two questions: whether the defendant actually copied and whether the defendant copied protected elements, or misappropriation, as they call it, misappropriated. And then we have to break this down. So we're on the question of the copying of the copyrighted elements, and we have two questions we have to answer: did the defendant actually copy, and whether the defendant copied protected elements. Was one of the exclusive rights infringed upon? There does not have to be commercial gain. The defendant can be, these are kind of recaps, there doesn't need to be any commercial gain, and the defendant can be liable even if he or she did not know that he or she was using copyrighted material. Remember that? All you need is some conscious use or will or volition. Doesn't need to be I'm intentionally infringing on this work right now. There's no intent. You just have to be using it. Using a work that is not yours and you do not have permission is kind of the key here. It is going to be copying if you're using somebody else's work without permission. We talked about this under reproduction. We will get to, right now we're talking about the plaintiff's case. This is what the plaintiff has to show. If you walk into Staples and make a copy of a chapter of the Harry Potter book, you have infringed. You have copied somebody else's work. The question of whether or not you think it's proper, i.e. fair use or de minimis, those are defenses, and those get raised after the plaintiff has proven that there's infringement. That's the defense. So we're just talking about copying. Actual copying can happen in one of three ways. The defendant made a literal copy of the work, my Harry Potter example. The defendant worked from the copyrighted case. Remember our Coons case? He worked from the photograph of the couple holding the puppies to create the sculpture. He worked from it. He actually removed the copyright notice from it, and he worked from it, and he was found in infringement. That wasn't a fair use in that case. It was an infringement. So defendant makes a literal copy. Defendant worked from the copyrighted work. And number three, subconsciously used the work or worked with the copyrighted work in mind. That sounds pretty funny, but we don't need intent, remember? Subconsciously used the work or worked with the copyrighted work in mind. This happened with the George Harrison versus the Chiffons case. George Harrison's song, My Sweet Lord, and the Chiffons song, She's So Fine. There is a link in Moodle under the additional materials. You should give it a listen. Pause here and give it a listen. I was able to find something that they overlaid the songs together, so you can really tell there's some similarities. So George Harrison wrote the song My Sweet Lord He said, this went to trial. He said he was inspired by the Edwin Hawkins singer's version of Oh Happy Day. That's an older song. If anything gave him pause about his song in progress, he thought it was the mentioning of God in the lyrics. He goes, I thought a lot about whether to do that because I would be committing myself publicly, and I anticipated that a lot of people might get weird about it. That was his concern. Apparently no one in his George Harrison's inner circle got weird about the obvious similarities of his new song to the Chiffon song, He's So Fine. And it was suggested that maybe they feared that calling out a Beatle a thief might be stronger than telling him the truth, because if you haven't heard it yet, give it a listen. He says, I wasn't consciously aware of the similarity when I wrote the song, Harrison said, but once it started to get a lot of airplay, people started talking about it, and it was then that I thought, why didn't I realize? It would have been very easy to change a note here or there and not affect the feeling of the record. Harrison tried to settle out of court. His manager even offered to buy the Bright Tunes entire catalog. That's who was the owner of He's So Fine. But the publisher said, nope, they dug right in. They insisted that they wanted Harrison to surrender the entire copyright, obviously, because it's a Beatle and that's a big money-making song. And then there was this 4-year stalemate, and the case went to trial. And the two songs were played side by side and were painstakingly analyzed. In the end, Harrison was found liable of subconscious plagiarism. And he had to pay almost $2 million of the earnings from My Sweet Lord to Bright Tunes, who own He's So Fine. So, give it a listen. I don't think they needed to pick it apart too much, because it is quite similar. Independent creation is not infringement, right? Despite coincidental similarities, there's no infringement. So we're dealing with actual copying versus independent creation when we're talking about whether or not defendant copied. And how do you prove copying? How might you prove copying? By admission, right? The defendant's own admission. Rarely do you ever get that. Unless they're going to say, I did, yep, I copied, I used it, and it's fair. In the Coons case, it's a fair use. You might have an eyewitness, you might have some video recordings, you might have records indicating that the defendant had some sort of access or exposure to the work. Courts look at several factors considering copying. Similarity, the more similar the work, likely copying occurred. The test for similarity is whether an average lay observer would recognize the alleged copy as having been appropriated or copied from the copyrighted work. I mean, take a little listen of the George Harrison Chiffon's battle as a lay average observer or listener. Defendants' access to the work is something else they consider. To what degree? Obviously, the more access, the more likely they copied and then created, like the Chiffon song. That was a hit song played all the time on the radio. There was no avoiding having access to that song. Despite, though, however, having access, if there is no similarities, there's going to be no copying. They can have all the access they want. But if there's no similarities, there's not going to be a copyright infringement. The courts consider evidence of independent creation. What might that be? Independent creation. Notes that the person kept. Drafts created during production of the work. Witnesses describing that the defendant worked on the work. Maybe they can show they used a different work for inspiration, like something that was in the public domain. Maybe defendant's work was completed before plaintiff published their work. That could be evidence of independent creation. Take this example. Author of the book Southern Dell claims copyright infringement by the author of Mint Tulips, showing many similarities and elements in the two books. And then the author of Mint Tulips stated that she simply copied elements from Huckleberry Finn, which is in the public domain. That would be And if that's the case, comparing the two of those, that would be a great evidence for independent creation, leaning towards a non-infringement ruling. So let's go back to the Moscow case. We talked about this when we were talking about spare. Let's go through this case is also in the book. I'm not gonna. It's a longer case, but I'm not going to go through it all. I'm going to kind of give you the aspects of what happened here. So, the parties concede the first element, that the plaintiff owns the copyright in, the New Yorker picture. Okay, nobody argues that. So most of the case is dealing with the second element, which is copying. And the court is reviewing those two elements of copying. Defendant had access and similarity, right? Similarity versus some independent creation. And you may recall when we talked about this under our what subject matter isn't copyrighted, that the idea of access was not, access was proven fairly easily. The art director of the movie, Moscow on the Hudson, he admitted that he specifically referred to the Steinberger's poster, and indeed that he purchased it and hung it, and among other things in his office it was hung there. Furthermore, he claimed explicitly directing the outside artist who made the Moscow poster, who he retained to do the design, to use the Steinberg's poster to achieve a more recognizable New York look. So that was access, right? That was quite easy. Does it sound very familiar? Does it sound like our Coons guy with the puppies, the puppy picture, the couple and the puppies, right? Oh, here's this copyrighted work. I want to use it. So now we had to pick apart, the court had to pick apart similarities. And the court ruled that they were strikingly similar. A few things on the scène affaire, just to recap: ideas and its expression. They have to distinguish between the two. There was no dispute that the defendant's use of the idea of a map is not infringement. However, the court says one can see, just looking at it, without even picking apart at first glance, a striking stylistic relationship between the posters. And since style is one ingredient of expression, this relationship is significant. Defendant's illustration was executed in the sketchy, whimsical style that has become one of Steinberg's hallmarks. Both illustrate a bird's-eye view across Manhattan. They depict 4 city blocks in detail. The strongest similarity that the court found that was evident is the vantage point of view looking down a wide 2-way cross street that intersects 2 avenues. The court says, while not all of the details are identical, many of them could be mistaken for one another. For example, the depiction of the water towers and the cars and the red sign above the parking lot, and even many of the individual buildings. In addition, the movie company artist used the childlike spiky block print that has become one of Steinberg's hallmarks to letter the names of the streets in the Moscow poster. That can only be explained by copying. This is no inherent justification for using the style. While defendant's poster shows the city of Moscow on the horizon in far greater detail than anything is depicted in the background of plaintiff's illustration, the fact alone cannot alter the conclusion here that substantial similarity does not require identity, and duplication or near identity is not necessary to establish infringement. But here, ultimately the court, if you could, I mean, you guys are looking at the picture, the court actually concluded that this was infringement. They rejected the scène affaire, as we talked earlier, those things that are incident, characters, and setting. That didn't apply here. Fair use. The movie company tried to argue fair use in saying that the poster was intended to be a satire. The courts didn't buy that claim at all. They say there's no way that this movie poster was designed to be a parody of the Steinberg illustration. The poster merely borrowed numerous elements from Steinberg to create an appealing advertisement to promote an unrelated commercial product, i.e. the movie. No parody of the illustration is involved, and the defendants are not entitled to protection under parody and fair use. So this case is a example of infringement, right along the lines of the case involving the puppies. Let's look at this one. We have another photograph. We have an actual photograph, and then we have another movie depiction poster here. And we have a copyright infringement case. So this appeal concerns the scope of a photographer's copyright, and the court has to determine whether the images are substantially similar for purposes of copyright. So we have Jack Lee. He took the famous photograph of the bird girl statue in Savannah's Bonaventure Cemetery that appears on the cover of the best-selling novel Midnight in the Garden of Good and Evil. Warner Brothers made a film version of the novel and used images of the bird girl both in promotional materials and in the movie itself. Lee sued Warner Brothers, asserting that it infringed his copyright in the photograph of bird girl. So you can see that the one with the title on it is the movie, the infringement, the claimed infringement. And the other on the left is the photograph. So in 1993, Random House commissioned Jack Lee to take a photograph of the cover of Midnight in the Garden of Good and Evil, which was a novel. After reading a manuscript of the novel, Lee explored appropriate settings in Savannah and ultimately selected a photograph of a sculpture in the Bonaventure Cemetery known as the Bird Girl. Sylvia Shaw Judson had sculpted the Bird Girl in 1938, and she produced 3 copies of the statue. The Trousdale family had purchased one of the statues and placed it in their plot in the Bonaventure Cemetery. The novel does not mention the Bird Girl statue. Lee granted Random House permission to use the photo, but retained ownership and registered his claim of copyright. In 1997, Warner Brothers produced a movie based on Midnight and decided to use the Bird Girl statue on promotional materials and at the beginning and end of the movie. Because the Trousdales had removed the statue from their cemetery plot after the book's publication, Warner Brothers made a replica of the Bird Girl with the permission of the sculptor, Sylvia Shaw Judson. Well, actually her heirs, because she had since passed. The company then took photographs and film footage of the replica in a new location in Bonaventure Cemetery. Those images are the subject of the lawsuit. So 3 segments of the film footage depict the Bird Girl statue, one in a promotional clip, and the others appear at the beginning and end of the Warner Brothers movie. 6 still images feature the Bird Girl, a promotional photograph, and nearly identical picture on the Good and Evil website, and which is a newspaper kind of advertisement. Lee alleges that these images infringe his copyright. Okay, so to establish our copyright infringement, what do we got to prove? Plaintiff that he owns a valid copyright and that the defendant copied the original elements of the work. The plaintiff obviously can prove that he is the owner, but he has to prove copying either directly or indirectly. So he has to establish that the defendant had access and produce something substantially similar. Substantially similar, in this sense, exists when an average lay observer would recognize the alleged copy as having been appropriated from the copyrighted work. And again, no matter how the copying is proved, the plaintiff also must establish specifically that the allegedly infringing work is substantially similar to the plaintiff's work with regards to the protected elements. Okay? Nobody contests the ownership of Lee, as I just said. Lee's copyright does not cover the appearance of the statue itself or of the Bonaventure Cemetery, for Lee has no rights in the statue or its setting. So he has no rights to the location, and he has no rights to the statue. He had to ask permission to take a picture of the statue. And we know that Warner Brothers got permission to create a replica, so we're not even looking at the same statue. While Lee may have been the first to think of the statue as evocative of the novel's mood and as an appropriate symbol of the book's theme, but copyright law protects only original expression, not the ideas. The court determined that the eerie spiritual mood was scène faire, expression commonly associated with the subject matter, cemeteries, and thus non-original and unprotected. So this, we're kind of working through here. Lee contests the notion that cemeteries are typically portrayed in an eerie spiritual manner, but there's no need to determine whether scène faire applies here. The court did it nonetheless. The court said that the film sequences featuring the Bird Girl statue are not substantially similar to the protected elements of Lee's photograph. In one sequence, the cemetery is shrouded in fog, revealing only the Bird Girl and a Celtic cross, a decoration absent from Lee's photograph. The camera frame also crops the head of the Bird Girl statue. A second sequence is shot at least partly in color and in broad daylight. The statue itself is never shown, or the front of it's never shown. And as the camera pans up, it shows only the upper portion of the statue on the left side of the screen. In the final sequence, the camera rotates around the statue, beginning with a side shot, and captures only the head and shoulders before panning back to show the Bird Girl's torso. Again, the statue is on the left side of the screen, and the sequence is shot in the daylight. The film sequences were not shot in the same section of the Bonaventure Cemetery as Lee's photograph, so the surrounding gravestones and greenery are different. These film sequences have nothing substantial in common with Lee's photograph except the statue itself. So here, the court said, nope, no infringement. They didn't even have to answer, fair use. This is independent. This is an example of independent creation. So to just kind of recap, copying does not need to be literal, except if we're dealing with the sound recordings. All you need is substantially similar of the protected elements of the copyrighted work, and the test whether the works are substantially similar to the ordinary observer, i.e. does the total concept and feel. Check out the total concept and feel of the copyrighted work. There are some exceptions, fair use, de minimis, right? We talked about that relative to music. That's the trivial use of a copyrighted work, and we discussed that relative to music and sound recordings, but it also applies to other works as well. I note the music sampling at the bottom. We've already rolled through that aspect. And just to kind of touch on de minimis and other works recently, these are two earlier this year cases back to back out of New York State. The bottom one, Solid Oaks versus 2K Games, a court dismissed a copyright infringement case involving the tattoos on the players that are shown in the video games. The tattoo artist claimed copyright infringement, and the court said, no, that's just too trivial. That's de minimis relative to the work. The other case filed by LMNOPI Inc. versus XYZ Films. I don't know where the names come up with, but a court, again, New York court dismissed the case involving a few seconds of graffiti or street art. You can kind of see it's a little blurred out, but the graffiti on the street scene is shown on the opening scene of a Netflix movie, Bushwick. a couple seconds, maybe 5 tops seconds, 4 or 5 seconds. And the court said, no, that's de minimis as well. Defenses, fair use is and can be a defense to a claim of infringement, and it often is raised as a defense. But before it can be raised as a defense, an individual has to say, yeah, we've used it. They have to kind of concede that they're using somebody else's work. But if a court rules that, yes, you're copying someone else's work, they can turn to okay, well, then my use is fair. But fair use is used as a defense. Another defense is statute of limitations. What is statute of limitations for copyright infringement? Well, what is statute of limitations? That's the period of time that a plaintiff has to bring their case once they feel that they have been wronged. It's not, you can't decide to sue someone 10 years from now from what happened 10 years earlier. There's limits on when plaintiffs can bring their lawsuits in all sorts of actions. And in copyright infringement, that is within 3 years after the claim accrued, where the claim accrued. What does that mean? It's a little hard to say. It's a little harder to say with copyright terms than it is to say, well, let's say take a car accident, right? A car accident happens today. We know the date of the car accident. So if the statute of limitations for, like, I got hurt to have somebody pay for injuries is, let's say it's 3 years, they have 3 years from the date of the accident. That's a pretty easy date to calculate. You can identify it. But with copyright, you have a continuous use or a continuing wrong. So acts are part of the continuous course of action. And I'll give you the example of Spirit versus Led Zeppelin. And those two songs you can listen to. Stairway to Heaven. Well, there's 2 songs. They're in Moodle under the additional resources. The band Spirit accused Led Zeppelin for infringing on its song Taurus when it wrote Stairway to Heaven. This is a fairly recent case over the last few years, considering these songs were written in the 60s. And then you're like, whoa, well, what about this 3-year statute of limitations? Well, every time Stairway to Heaven gets played, gets used legally somewhere, i.e. licensed out, played by the band, these are all, according to Spirit, these could all constitute each wrong, a continuing wrong, and these generate a consistent use or a continued wrong each time, and each time the clock is resetting. So the statute of limitations is a little, can be a little dicey in this area, depending on the type of work you're dealing with. Obviously, let's say you have a photograph that you took of a moose that ran across campus, and then I use that photo without your permission to promote my law firm. I use it in an ad for my law firm that runs in the newspaper on one Sunday. From the point of my use, that Sunday it appears in the newspaper, that you have 3 years to sue me, and I never use your photo again. And then it's 3 years and 2 days later, and you decide to bring an infringement suit. It's not, let's say you just discover it. Doesn't matter, it's from the date that I used it. So if you discover it 3 years and a day later, you might be out of luck. Actually, you will probably be out of luck. Let's talk about declaratory judgment action. This is a type of action that some entity accused of infringement can bring in court, asking the court to make a determination. So this is the person being accused running to court first and asking the court to make a ruling. So what they're asking the court to do is, please make a declaration that what I'm doing is or isn't infringement. And it's usually done when time is of the essence. One of the cases in the case analysis is one of these actions. We got one party is trying to open a play in New York City. Dr. Seuss Enterprises is accusing him of infringement on one of their works. Rather than wait for Dr. Seuss Enterprises to bring a lawsuit against him, the writer of the play goes to court and asks the court, please make a declaration. Otherwise, this is going to hold up my play. I want to make sure the claim was fair use, and you'll see it in the case. So it's the one being accused of infringement can go first. You don't have to wait for the plaintiff to sue. They can go and ask the judge to make a call. Now I have a few. I know we're running a little longer than I like to be on these videos, but I just want to run through a series of cases. It probably won't take that long, and they're all linked in Moodle under the additional resources materials. Kind of work through some of these cases. I already gave you a snapshot of Led Zeppelin. Give the songs a listen. Led Zeppelin won the case. The jury determined that the songs were not substantially similar. However, because the case involves songs that were subject to the pre-1972 rules for sound recordings, the court didn't allow the playing of the songs, but only allowed for interpretation of sheet music by experts. The access element was determined because the band Spirit was on tour with Led Zeppelin at one point prior to Stairway to Heaven's creation, even though Jimmy Page said he never had any access and he had never heard the song, he'd never heard of Spirit. So give those two songs a listen and think about whether or not you think there was infringement. That case was on appeal. It's gone up to appeal many times. It's on its way back down for another review, and the directive is that the songs could be played the next time around. Marvin Gaye and Robin Thicke, give those songs a listen. It was claimed that Robin Thicke infringed on Marvin Gaye's hit Gotta Give It Up with his song Blurred Lines. This is another case determined by a jury, except in this case, they determined there was infringement. Access was determined because Marvin Gaye's song was so popular and heard on the radio that anyone could have had access. And also in this case, the jury got to hear the two songs together versus just interpreting sheet music, and they found that they were substantially similar. So give that a listen. Not on my screen here, but it's listed in Moodle. Katy Perry was recently sued by Marcus Gray, and she lost when a jury found that she infringed upon Gray's song Joyful Noise when she wrote Dark Horse. Perry claimed that she never heard Joyful Noise or heard of Gray, and that's usual assertion to these claims of access. However, access was proven because there was a connection between her and the record label Gray was on, and that she had attended a performance of his. The jury awarded Gray $2.78 million. But earlier this year, an appeals court overturned the decision, ruling that none of the individual elements that comprise the ostinato, the musical phrase, the repeated musical phrase, and joyful noise are independently protectable under copyright law, nor is the specific combination of them in his song. It is undisputed in this case, even viewing the evidence in the light most favorable to Gray, that the signature elements of the 8 notes ostinato in joyful noise is not a particularly unique or rare combination, even in its deployment. In its deployment. That's what the judge said. So that's interesting. You listen to the two and tell me whether or not you think they're similar. And then one last quick case. Reposters. Ben and Ray Lay, they're brothers who run Horizon. It's a comic book outfit. They brought a lawsuit against Marvel Comics, claiming they infringed on their series Radex. And this case is still ongoing, but the court has determined some issues in the case in favor of Marvel and then against Marvel. The argument was the fighting pose, the idea of a highly mechanical suit of armor, the fighting pose as unprotected elements. Are they center fair in a comic book or a superhero genre? Where we are with the case is the Marvel asked that the case just be tossed out, claiming that these things are center fair and they're not necessarily related to the expression. The court said, well, at this early stage in the game, when it comes to the particularized expression of the idea, The judge noted some non-identical similarities, like the hairstyle, well, some similarities like the hairstyles, the use of the blue light, the color of the suits, with the ultimate conclusion that the works do share some similarity in their total concept or feel. So what the judge is left here deciding. First, I'm going to back up a little bit. First, the judge said, yeah, the mechanical suit of armor, sent a fair of comic books and superheroes, noting like the boots are different colors and the blue gray on Radix, the red gold, the heels appear different. The top of the foot is totally different. We have an angular receding in the shin cover in Radix and the Iron Man gold and protruding from the toe. The judge kind of tossed some of those ideas that were sent a fair. However, the one thing he would not toss is what we're looking at right now. This is the one thing that survived the case, is the hairstyle, this concept and feel, right? How do you feel about this? You're looking at it. What's the total concept or feel? That's what our lay observer is looking at. Do you see some similarity here? Is this substantially similar? The other question was access. Yeah, these two guys worked for Marvel at one point, and they had showed Marvel this particular Radix series. So there was access. So the judge said, yeah, look at the hairstyles. We got this, the blue light, the glow blue light, the color of the suits are somewhat similar. The judge wouldn't toss the case. He wants the jury to hear and decide whether or not, under the layperson, under the total concept and feel, that this is substantially similar. So as of right now, there's no answer on this. But that completes the infringement. We have one more section of infringement. We're going to be bringing in some other people to the party.